Hello. Do we have rights? Well, normally, most of us, all of us, we have a tendency to think that yes, we do. Are our rights well protected? And again, usually we have a tendency to think that yes, they are. Still, we can lose all, or at least almost all of our rights, at least in practice, without even being imprisoned for doing something wrong or without being kidnapped or enslaved, God forbid. And I'm not even talking of marriage. We can be declared legally inept, legally incapable. And that means that the court would tell the others that we're incapable of exercising our rights, which would mean that technically, theoretically, our rights are still with us. But what's the use of it if we cannot exercise the rights? We cannot decide what to do with our property. We cannot decide what to do with our money. We cannot buy things. We cannot get into a contract. We cannot decide where do we live and what happens to our house or another residence or a condo or whatever. We cannot decide what medication do we take or do we not take, what medical treatment do we accept or not. We cannot decide what entertainments do we have, what movies to watch, what books to read, if we still can, what to put on, what will be on our plate, and so forth and so forth. So what's the use of still technically, legally having rights if in reality we are worse than imprisoned because we are basically totally, fully powerless, or at least to a certain extent? That's actually what happens when we legally lose our ability to exercise our rights, whatever the rights are. How can that happen? Of course, the first idea is to soothe and calm ourselves down, that it only happens to those who unfortunately get into Alzheimer's or some other kind of dementia, and that usually comes with significant age and so forth. But in reality, no, not necessarily, because first of all, dementia can come in a rather early age, or coma can come, or God forbid again, but still, or some other kind of like mental disorder. And even if a person of a certain age and the heirs are tired of waiting, basically, but the brain is still functioning properly, then the allegation that you can no longer exercise your civil rights would be still as dangerous and offensive as it could be significantly earlier in somebody's life. Still, the situation might come. It might come if you're alone and you're getting still being of sound mind, but getting more and more vulnerable, and you continue to live in your house, and as many other people of certain age, you maintain your own routine and everything goes acceptable, though it's harder and harder to just tidy things up or so forth. But eventually you could fall, for example. And if your neighbor sees that nobody comes to your rescue, that neighbor, out of best of the neighborly feelings maybe, can call police, and police could bring you to a hospital, and then doctors, again fulfilling their duties, they could inform the office of the public curator, and then some social worker would come and some doctor would come, and they could conclude that you can no longer exercise your rights because you basically can no longer take care of yourself, but because you most probably oppose the idea to go to some long-term care facility, the conclusion might be that you cannot reasonably and correctly assess the gravity of your situation, hence the allegation of mental incapacity, and voila, eventually you see yourself in front of the judge, or maybe even the judgment is rendered in your absence because, again, according to the report, you are vulnerable, you're weak enough, and you should not be disturbed by the hearing itself. So again, not only of some malicious intent, not only when somebody think that you're just sitting on their money because you're too old and your children or grandchildren, God forbid again, but still that happens, uh, think that if you continue to do this way, the inheritance would diminish, so they want to limit your powers to spend your money, for example. But it might be your business partners, somebody else who's interested and who disagrees with the way you're living and the way you're managing your affairs. But it might be somebody who is simply there to help. At least that's the idea. But the way they help might go against what you actually prefer for your late years or just for your average years if something suddenly happened to your mental capacity. So let's take it seriously. For many people, being legally declared incapable is worse than to go to prison, because imprisonment usually comes with a term, but if you're declared incapable, that might be for life. And you're vulnerable and poor in many senses position will continue. And of course, you know that there are situations when not only dignity, but even body of those people who can no longer speak for themselves is being abused in many bad ways. I'm not saying that necessarily that's the case always, but that unfortunately can happen. So there is a reason to take the idea that however good is your brain functioning now, that eventually there might be this sad situation when somebody would at least attempt to declare you legally incapable. That situation might come, and it's a good idea to take it seriously. So what can you do? Well, first of all, of course, you should remember that exactly because it's serious, until you're declared legally incapable by a judge in court, you're presumed to be legally capable. And if you do not demonstrate some grave symptoms of some sort of dementia, which would probably allow a notary or another business counterpart to suspect that maybe you're not in your best mental shape. Other than that, you can still buy things, you can still make decisions about your life, you can still arrange for some repairs and renovations and something, just modernization, something like that in your own house. Even if it's expensive, you can still buy some property and hypothecate, like mortgage it out and so forth. You can still get some credits as long as you just have your rights. Again, sometimes you might do some stupid things, some unreasonable things, but at least you'll retain your rights to do so. Because as one of the judges mentioned, stupidity itself is not illegal, and it's still your right to take that way. But if somebody, either in bad faith or in good faith, apply to the judge, to the court, trying to deprive you of this ability to exercise your rights, you will receive a notice. Well, again, there might be some sort of foul play, and the notice might be delivered to your official address while you're no longer there, for example. But at least the requirement is that the notice is delivered to you even if you're in hospital. And there is a standard form for that approved by the Ministry of Justice. So the very first thing that you should remember, that if something like that happens and you don't think that you're losing your mind, actually, then until the judge says otherwise, you're still legally capable, and you can hire a lawyer to protect your rights, and you can invite a doctor for a medical evaluation, to undergo some mental tests and so forth. You can invite and hire a social worker for psychosocial evaluation, so that when eventually you come to court and you insist that you wish to come to court, you could testify before a judge, and you could bring, or your lawyer could bring, your medical evaluation, your psychosocial evaluation, to counter whatever the arguments brought up against you there before the judge. So you can fight, basically. But for just being simply outraged and deeply offended, you can fight, you can prove your cause. You can show that, yes, maybe because of certain circumstances in your life, you are more vulnerable than before, you're weaker than before, and maybe you need more time to understand what's going on and to make a reasonable decision, but at least you can do that. You're capable of doing that. You're capable of making your own arrangements about your care if you're no longer able to do many things on your own, and so forth. What, on the contrary, what happens if you think that probably that's the case? That probably your memory is not serving you well and it's getting worse and worse, and that you're just mixing up things, and that it becomes dangerous because it might cause fire or flood in your house or some damage, or you could get frozen if you go outside in winter and forget where you are and where you're going, or you're getting not so much able to drive your car. Well, you still have this reasonable appreciation of where the things are going, but you notice that something is going on. In such a situation, especially after recent amendments to the law, there is a thing that is available to you which is called protection regime. Basically, yourself or with somebody's help, the person you trust, the person who loves you, the person who cares about you, you could again go to the judge, to the court, and ask to open this protection regime and to establish a degree. Because again, it's not like black and white, especially now. It's not like 0 or 1. The judge might say, okay, this, and this you still can do on your own. And your decision on this, and this still matters. But significant financial decisions, for example, significant life arrangements, medical arrangements, those should be done with the help, with assistance, or even under the administration of the person that you have chosen and the judge agreed, and that person would be answering to you to a certain degree, but also to the office of the public curator or to a tutorship council established, so some other people could oversee, in order again to prevent some kind of abuse. And when I'm saying the word abuse, it doesn't only mean that somebody could steal your money or sell your property and disappear with that. There is much more prosaic thing than that. A person who at first was ready to help could get tired, could get bored, could feel that he or she is no longer capable of continuing with all the burdens of such a life. And if there is no accountability, you might end up neglected, and your well-being will be in jeopardy. This is why it's a good idea to have this tutorship council, that the body to overlook or to oversee what's going on. And if your current tutor cannot continue like that, then there might be a possibility to establish somebody else, even if by then you won't be able to participate significantly. Also, under this regime, there is the idea of reevaluation every several years. your situation, because, well, there might be improvements, and who knows, and the medical treatment develops. And again, if something happens to you in a like middle age or even a younger age, some, God forbid, trauma, like somebody just hit your head, for example, or something. So there is a hope that things will be improving. Then eventually you might be reevaluated, and the judge might say, okay, that now you can exercise your rights on your own again. And then whoever was there to help you will have to make a report to you, a financial report or a report about all the affairs. And technically at this point, you might even go after that person, claiming that something was done in the wrong way. Of course, if the situation develops in a less optimistic manner and eventually we pass away, then whoever will become the liquidator, the executor of your estate, of your succession, that person will be there, will be in charge of taking that financial report and evaluate what was going on. But mostly at that time, of course, the question will be about money and property. Uh, Sometimes you would like, because there will be a will, or at least you can make a will, you might foresee in the same person to be a liquidator in your will. But again, if you just waited until there is a situation when there is a need to open your protection regime, then there might be that one person becomes your tutor and another person by your will later becomes your liquidator, and there might be a conflict between them. But again, there are situations. Something you should probably think of in advance. And that's the third part of what I was going to talk about today. Because you can think of all that well before something happened. Instead of waiting for the situation where protection regime should be opened, you might prepare your own protection mandate, or so-called mandate in case of incapacity. Well, on paper, it's more or less a power of attorney, procuration. The difference is that the regular power attorney, a regular power attorney, is something you can do just on your own and give it to somebody else. Well, sometimes a notary is needed. Sometimes you could do it just in the bank. But still, it is such a power attorney, the regular one, the general one, or some particular one. It's valid from the moment when you issued it. But the mandate in case of incapacity does not become valid simply because eventually some doctor says that, well, your mental ability is diminished. You would still need, or the person who is named as your mandator in this mandate in case of incapacity, in your protection mandate, that person would need to go before a judge and prove again that now it is the point. Now this is the medical report. Now this is a psychosocial report. And again, depending on what's written in your mandate, because some people only write mandates in case of like total incapacity. It might be a smart idea to add what you think should be added in case of partial incapacity. Again, when you can do certain things, but you cannot do other. And there might be specific ideas, specific wishes. And this is where a mandate in case of incapacity is like a little bit close to a will. Because you write a will in anticipation of the time when you will be no longer capable of making any other wishes. And the mandate in case of incapacity is governing the time when you're still there, but you cannot already express your wishes, at least serious wishes. So in the mandate in case of incapacity, in the protection mandate, you can stipulate what kind of medical treatment you accept and not. If you wish at a certain situation that your mandator proceeds with euthanasia procedures or not, if you wish to be treated this and that way and placed in that or that long-term care facility, as long as your financial situation allows that, of course, but still you can make those provisions. If you're careful enough, you could make even provisions about the particular care you would need and particular entertainment that would be required. But of course, the more complicated you put it there, the nearer the situation when, or the more possible the situation when your mandator, the person that you wish to establish as your administrator when you can no longer do it yourself, that person who at this moment when you write it might be a best friend, might be a family member, might be simply somebody who doesn't want to upset you, so that person agrees that you put his or her name in there. But then that person might decline, saying that, oh no, I cannot do that. I have my own children, I have my own husband, I have my own wife, I have my work, I have my career, I have my own health problems, so no. And if you put there only one name, then we're back into the situation of like opening a protection regime. So if you wish to control your future in a more scrupulous way, you might be interested in putting there several names, like substitute, in case this one refuses or dies, God forbid, or something happens. This one comes in, and this one comes in, and this one comes in. Because again, legally speaking, technically speaking, you do not lose your rights. The rights are still there. It's just somebody else will exercise them in your name. And as you can imagine, it's better to have somebody you can trust with yourself eventually, when nothing better than that could happen in your life. So think of a mandate, a protection mandate, a mandate in case of incapacity. Think seriously, choose wisely. Remember to name substitutes. Remember that even in that situation, if you think that the application to declare you're legally incapable is premature, you could still fight for your own freedom, basically, for your own rights. You can defend yourself. You could try to prove to the judge that you're not incapable. You're simply weak, maybe temporarily, but no more than that. In any way, same thing as with a will, probably. If you do not think of it, if you do not make your own preparations in good time, then when you really need that your rights are protected, unfortunately, there might be a situation when you're no longer able to do anything about that. Think in advance, think wisely. Thank you, and have a nice day.